As you've heard, the Attorney-General George Brandis has defended the government's plan to amend a key part of Australia's racial discrimination laws, saying people have a right to be bigots. The Abbott government has promised to amend the Racial Discrimination Act by repealing Section 18C, which makes it unlawful for someone to publicly offend, insult, humiliate or intimidate a person or group of people. With his view on this, here's Chris Berg from the Institute of Public Affairs, who's the author of the book In Defence of Freedom of Speech from Ancient Greece to Andrew Bolt. So Chris Berg, thanks for coming in. Good to see you. Do you think repealing part of the racial discrimination laws is the right thing to do?
Absolutely, and the Attorney-General was very clear about the importance of freedom of speech, which has been a major debate, as many viewers will know, for the last couple of years, not just with the Andrew Bolt case, but with the Gillard government's media reforms, the Human Rights and Anti-Discrimination Bill. This has been a big issue for quite some time, and it's good to see that the government is moving on what it's described as its freedom agenda.
So this doesn't give a green light to racist hate speech in Australia, as claimed by Senator Brandis's counterpart in opposition?
No, I don't think this does give a green light to anything. What this does is prevent the law from clamping down on our free expression. The idea that to repeal a limitation on freedom of speech is somehow licensing it or somehow approving of it is absolute nonsense. Just because adultery isn't illegal doesn't mean it's a good thing. Just because racist speech isn't illegal doesn't mean it shouldn't be shouted down and responded to in a genuine free speech country.
But what message does it send to the community who might be made nervous by hearing what's going to happen?
I think the message that it sends to the community is that the government values freedom of speech, and Australia is a country based on its liberal values that supports free expression as not just an individual right, but an essential element of the Australian democracy. And the High Court's recognised that free expression and free political communication is an essential part of the Australian democratic system, and I think that it's time that we started pushing towards that once more at the statutory level.
But isn't this removing some protection from those who are vulnerable in society?
I don't think it actually does. What this particular amendment does is repeal 18C, which makes it unlawful to offend, insult, humiliate or intimidate. Now, a lot of people focus on the word intimidate, but intimidation is covered by a wide range of existing state and Commonwealth laws as well. There are a large amount of protections, and a lot of people forget that we also have state-based racial and religious vilification laws too. I think that the practical impact of this change won't be as significant as a lot of people have suggested, but it does suggest to everybody, and it does suggest to the voters and to the country at large, that freedom of speech is an essential human right, an essential Australian value.
Chris Berg, thank you.
Thank you.